Mr. Abbott is here today after failing to appear before referee Delmont on March 13th, 2023. Bond is currently set at $1,856. This is the first bench warrant. He reports no employment. Last payment made on this account was on March 2nd of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 5th, 2023 at 8:00 a.m. before this court.
Okay, thank you. Mr. Abbott, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on April 5, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post the bond, sir?
I can post a small bond. I come in and I got an employment. I'm laid off. They take my money out my check during the summers, and because I do lawn care, I ain't been able to pay, so I've been making small payments. And I missed court. I thought it was the 15th, so I called the courts and talked to them, and I talked to the bench warrant guy, and he was trying to work with me, and I was trying to wait for the warrant to interlene and call him after I got the letter. So I didn't end up in jail with a bond, so I can resolve this because I got 4 babies at home.
Okay.
I got like $400 or $500 right now that my parents could bring down.
Okay. Okay. Well, let me do this, is I will reduce your bond, being that it's your first bench warrant, and that you had, again, made a recent payment. So what the court will do is, based upon your statement, what I'm going to do is I'm going to set your bond in the amount of $400. If you're able to post that, you'll be able to be released. Do you have any questions, sir?
No, Your Honor.
Okay, thank you. You have a good day, and then make sure you contact your worker and appear on the April 5th date, okay?
Who's my worker?
Excuse me?
Who is my worker?
You have to call the front of the court and they'll inform you who the worker is.
In each of these matters,
Yes, Your
Mr.
Honor.
Durand
Okay,
is
thank
here
you.
today after failing to appear before referee Jordan on August 23rd, 2021. In the first case, bond is currently set at $3,110. This is the fourth bench warrant. In the second case, bond is currently $1,452. This is the first bench warrant. He reports that he is employed at Modus. Last payment made on these accounts was on March 18th of 2023. For the record, that was their income withholding. Front of the court recommends that bonds be canceled in each of these matters and the enforcement action be dismissed. The enforcement officer will take action if necessary in the future.
Okay. Mr. Durand, you understand what the front of the court's asking for?
Yes, Your Honor.
Okay. They're asking that the court would in fact cancel the bench warrant previously ordered in this matter, dismiss your case, and that's because you are working and paying through income withholding, apparently. What the court will do is the court will cancel and vacate the bond previously, dismiss your case. That will allow you to be released, okay?
Thank you, Your Honor.
Okay, thank you, sir. Court will end this matter at
Is here today
8:37
after
a.m.
failing to
You're free to
appear
go.
before referee Croteau on May 26, 2022. Bond is currently set at $1,410. This is the second bench warrant. She reports no employment. Last payment made on this account was in February of 2021. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 5th, 2023 at 8:00 a.m. before this court.
Thank you. Ms. Hammond, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on April 5, 2023 at 8:00 a.m. Are you able to post a bond, ma'am?
No, I'm not.
Okay. Well, the court does note that you've not paid in excess of over 2 years.
I just job.
Okay. And it has been your second bench warrant. What the court's going to do is I'm going to reduce your bond in hopes that you'd be able to be released. But I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay, thank you, ma'am. Court will end this matter at 8:39 a.m. You're free to go.
To appear before this court on July 7th, 2021. Bond is currently set at $1,337. This is the second bench warrant. She reports that she is employed at Friends and Company. Last payment made on this account was in February of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 5th, 2023 at 8:00 a.m. before this court.
Okay, thank you. Ms. Phelps, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on April 5, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
My family should be able to, not the 1,300 though.
Sure. Okay. Well, the court does note that it is, again, that you have not paid in over a year, and it is your second bench warrant, so the court is taking that into consideration. What I'm going to do is I am going to reduce your bond in this matter. I'll set your bond. Okay, I'm going to set your bond in the amount of $400. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay, thank you, ma'am. The court will end this matter at
Tracy Miller versus Mark Miller.
8:42 a.m. You're
Today
free to
is
go.
Monday, March 27, 2023 at 9:02 a.m. Attorney Lisa McNiff represents plaintiff and Attorney Cindy Thomas defendant.
Good morning to both of you.
Good morning.
Good morning.
Court will note that this matter is before the court on the notice of entry of judgment of divorce submitted by Ms. McNiff. Again, Ms. Thomas has objected to that in pretty extensive objections. And likewise, Ms. McNiff has filed a response or answer to the objections.
Your Honor, I don't, just so the court's aware, I've not received that.
Okay,
We emailed it early this morning, and I apologize, Your Honor. I received the objection about 10 a.m. Friday, and with commitments to other cases, I wasn't able to get to the response until this weekend.
okay. Well, I've reviewed all of that and I've reviewed your response as well, Ms. McNiff. Is there anything else that you would like to add other than what's in the pleadings?
No, Your Honor. Although I would say if the court wants to take additional time, because I know there's a lot in both the objection and the response, in order to review the finding, I don't have any objection to carrying this over another week.
I reviewed everything over the weekend, so I have a good understanding of that. I've looked at, again, the objection. I've looked at my notes. I've looked at both judgments in this matter because Ms. Thomas has submitted a judgment as well. Okay. Well, Ms. Thomas, you're at a loss as you don't have the answer in this particular matter, but anything else?
Well, I'm just going to ask, could we pass for a minute and do another couple cases so I could grab it and look at it real quick?
No, I'm not going to pass. I've got too many cases and I'm
No,
sorry,
that's fine.
but it's scheduled. And obviously, as you can see, we're a little late this morning because we had so many matters at 8:30.
Okay.
Well, what the court's going to do is I have reviewed that and I've reviewed Ms. Thomas's judgment. I would note the court is troubled by the fact that we're now over 9 weeks post finding in this case. The court likewise did have a motion for clarification and that in fact, in addition to that, court would note that as I review the original judgment submitted by Ms. McNiff, it is riddled by mistakes and errors in this particular case. And many of those she acknowledges in her answer in this particular case. Court will note in this matter, there were a number of provisions that were included that would typically be included in a normal judgment where you'd enter it by consent, but this was not a consent situation. So I am removing the provisions that the court did not specifically order. That includes a number of ones that have been pointed out by Ms. Thomas. And likewise, it also includes one paragraph in the attorney fees provision pointed out by Ms. McNiff in this particular case. As I review Ms. Thomas's answer, and I mean objection and the judgment, it does appear that her judgment does comport with the ruling of the court. I will note, Ms. Thomas, just for your information, there was a typographical error on page 12. The first paragraph where you have the accounts being divided as of the date of filing, which you list as January 7, 2021. It should have been December 7, 2021. The court has made that correction or change to the judgment. And so what the court is going to do is I am going to enter the judgment as submitted by Ms. Thomas. I do believe that comports with the court's ruling. There are a little bit of things different as to the equalization payment and the payoff on the house, but I think those are a matter of really not substance in this matter, as in fact the payoff is going to occur in this matter. What I'm going to do is again, I hate to leave it open, but I am going to enter the judgment because I want this matter concluded. And so I am signing the judgment at this point. I'll enter the uniform spousal support order and the uniform child support order as submitted by Ms. McNiff, as there were no objections to that. And that will conclude the case. If there is anything that turns out in this matter, Ms. McNiff, of substance, I'm not saying form, because again, the issue concerning the equalization payments and the refinancing of the house is more of substance than form, because that's going to be taken into consideration. You can always file a motion at that point for, I guess you'd say, for amendment, et cetera.
So just so I'm clear, is the court accepting Ms. Thomas's calculations as to the equalization payments?
I am.
And the court is also accepting that my client is to be awarded the $15,000 thereabouts for the PTO?
Correct. Yep.
Okay.
Yeah, that, which now that you bring that up, Ms. McNiff, that strikes me, because that was the amount that was supposed to be paid to the defendant, isn't that correct?
Correct. He was supposed to be paid around $15,000. However, my client doesn't receive those funds until she separates. So
I understand. But I don't know when she's ever going to be separated. I'm not going to wait on that in this matter. So.
And the court's also accepting Ms. Thomas's accounting for the coverture fraction. I didn't even understand in terms of that we're not going to be allowed to include Mrs. Miller's time at Omni Credit Union with regard to her 401k account.
No, I think what Ms. Thomas was saying, that if you in fact include that as far as equalization, that it would skew that, because that was my understanding, Ms. Thomas, isn't that was premarital, or that
That entire account goes to her in my chart, because that was all premarital. So there would be no combination of the two. I did it every single account separately. That's 100% hers premarital.
We agreed that the Baird IRA is 100% marital. However, she also had funds in a separate account from Omni Credit Union that were rolled over into her KCCU 401k. And it's my understanding that Ms. Thomas's calculation does not take into consideration that period of time that she worked at Omni Credit Union and rolled over those 401ks into her KCCU 401k. So while I understand that I had mathematical error with the coverture fraction, I missed a year. I believe that the entire portion of her service at Omni Credit Union and KCCU should be included in that coverture fraction.
Okay, well, that's why I've left it open, Ms. McNiff, stating at this point, if there is in fact an error there, you can establish that and provide Ms. Thomas with the documentation. The court would entertain a motion to modify that particular calculation. But I do want finality. I do want this matter concluded. And that is why the court is entering that judgment at this time, subject to your right to do that and provide Ms. Thomas that documentation. Okay, that will conclude this matter at 9:11 a.m. You're free to go. Have a good day.
Today is Monday,
Thank
March
you.
27th, 2023 at 9:12 a.m.
Court will note the appearance of Mr. Grappos on behalf of the plaintiff, Ms. McKenzie on behalf of the defendant. This matter is before the court on the defendant's motion for change of custody. Ms. McKenzie.
Thank you, Your Honor.
Your Honor, I ask the court to regard this as unopposed because there was no answer filed.
Well, you can ask anything you want, Ms. McKenzie. I'm going to give Mr. Graffos the opportunity to respond.
Then I'll proceed. Thank you, Your Honor. On March 15th, 2023, the party's son's 9 years old, took a gun into his elementary school. And since then,
Ms. McKenzie, just so you know, I've read all the pleadings, I've read the response. I mean, I've read the motion. I'm well aware of that. So if there's anything else you have to add, you can do that, but I don't want to just hear a reiteration of what's in your motion.
what is new, Your Honor, that I learned from CPS on Thursday and from school records on Thursday was that there was ammunition, a full magazine of ammunition with the gun in the backpack. And that was news. That was news to me, and I found that out from CPS. And that was confirmed by a weekend call from the principal.
Okay.
So this case has become even more alarming than it already was, Your Honor. So that is what I have to add for this morning's purposes.
Okay, thank you. Mr. Graffos, what's your response?
As far as my response, Your Honor, first, this situation happened just last week. We're still in the process of gathering, we do agree that the incident happened. There was a firearm at the school. There are lots of conflicting accounts of how it happened and what was involved. I think what's important as far as an answer, because I don't have enough information to ahead to respond as far as a formal written response, but my presence here, and this is my response, so it is opposed. Secondly, we do have a concurrent CPS investigation. At the time of the incident, the minor child was returned to the plaintiff that immediately in the affidavit here, she did contact me, her counsel. I reached out to defendant's counsel to inform the defendant. Again, there's a lot of confusion as to what happened, what my client was told as far as contacting defendant and who was contacted when. Secondly, there is a CPS investigation. There's concurrently, I believe, still a criminal investigation until I get verification as to what's going to happen, how that's proceed. My understanding, based on information that I received from the investigator, was that the prosecutor wasn't going to go forward with any charges, but I haven't verified that. So yes, we do have an incident that happened. Also pursuant to CPS, the minor child is currently with the father. And until we get verification of either a formal safety plan or what the recommendations from CPS are, I think that maintaining the status quo is appropriate in this matter.
Okay. Well, the court does note in reviewing the pleadings in this particular matter that there's sufficient probable cause or change in circumstances to meet the Vivarka threshold for an evidentiary hearing concerning the issue of custody. As a result, the court does note that the referee has recently been involved in some show cause hearings as well. So the court's going to refer the issues of custody, parenting time, and support to the referee for an evidentiary hearing. In view of Mr. Graffos's statements here, the court would preserve the status quo of the child being in the father's care at this particular time, pending that particular hearing. So, Ms. McKenzie, you can enter an order to that extent, maintaining the status quo, and the court will refer the matter to the referee. We'll conclude this matter at 9:17 a.m. You're free to go. Have a good day.
Your Honor, may I inquire, tomorrow we have a custody evidentiary hearing and 2 show causes in front of Your Honor, which the court ordered on January 30th. So the court is not canceling tomorrow's matter, is it? Your Honor?
Yeah, I'm contemplating that.
Okay. All right. I thought I had maybe a bad connection.
No, you didn't. Well, I think what I am going to cancel that, and I'm doing it only because, as Mr. Graffo says, he doesn't have all the information, and we don't have anything from CPS apparently at this particular point, and I think that would probably be appropriate to get that before we proceed with the evidentiary hearing. And as long as the child is in the defendant's care, I don't see that there's any prejudice to him as as a result of the delay. So we'll put that over. And the reason I'm doing it is, like I say, the referee has handled a number of show cause issues. And so referee has a good background in this matter. So I'm going to refer it to him, and we'll see what happens at that point. So you can prepare that order, Ms. McKenzie, preserving the status quo.
Thank you, Your Honor. And one clarification, the court is transferring tomorrow's evidentiary or the matter that were scheduled in front of Your
Right.
Honor.
Correct.
Everything is going to the referee.
Everything's going to go to the referee. Yep.
Thank you, Your Honor.
Okay, thank you.
Thank you. Your Honor.
Yeah, the appearance of Ms. Bailey Hobbs on behalf of the plaintiff, Ms. Reed on behalf of the defendant. This matter is before the court on the defendant's motion for modification of parenting time and for the appointment of a guardian ad litem. I have reviewed the motion as well as the answer filed in this particular matter, so I don't need simply a reiteration of those, but anything else you would like to add, Ms. Reed?
Yes, Your Honor. Since filing our motion, there's been a couple of issues that have arisen. One of them is Mr. Irons contacted CPS and law enforcement with new false allegations, trying to allege certain things happened 3 years ago, which my client's in the position that nothing has happened 3 years ago. This is an additional effort to try and prevent her from having parenting time with Paisley. In addition to that, despite repeated requests that Mr. Irons not discuss this matter with Paisley, at the last parenting time therapeutic session with Ms. Katz, Paisley informed Ms. Katz of today's hearing and that she was going to be required to testify at this hearing, which is placing additional undue stress on Paisley as she is under 10 years old. She shouldn't know that these proceedings are occurring. She should not be required to testify at these hearings or be informed that she's required to testify at these hearings. We're just requesting that the court follow the previous order in that Ms. Katz has done her responsibility in meeting with my client and Paisley separately and has met with Mr. Irons. The prior order was very clear in that it stated that that was exactly what Ms. Katz was supposed to do, and that it was the reunification counselor to create a parenting time plan between Paisley and Melanie, which Ms. Katz has done. Ms. Katz does have the input of Mr. Roberts, which is the child's current counselor, and Ms. Katz agrees that there is anger issues and frustrations between Paisley and Melanie. However, Ms. Katz believes that it would be a mistake to lessen parenting time, and to work through those issues, it's important to adopt her recommendation for parenting time. She also believes it's important that a counselor that has all of the information and has met with all the parties and has all the background information does a psychological assessment, which is why she's requesting Dr. Haugen do that assessment, as he's very respected in that field, and any sort of inherent bias does not exist, as he's very experienced in doing these assessments and has been doing them for probably over 30 years at this point, and he's someone who this court is very familiar with. So those are the main issues that we're dealing with. And the other issue that has also come up is Mr. Irons has now started proclaiming to a number of people, including his mom, that Paisley is not his. And we have concerns that these declarations are being made in front of Paisley, and she's hearing all this in that house, and that also is having undue stress on her. So we're requesting that Ms. Katz's recommendation for parenting time be adopted. We're requesting the appointment of a GAL to advocate the child's best interest. And we're also requesting that Mr. Irons participate in parenting time classes or counseling, so he understands how his behaviors throughout the counseling sessions, as well as actions outside and in front of Paisley, affect her relationship with her mom and her mental health, as well as a psychological assessment to be performed by Dr. Howe.
Thank you, Your Honor. I guess this is the first time I've heard of any of these new issues. If I would assume if they were so pressing and so concerning that opposing counsel would have reached out to me and mentioned something, but I've not heard anything until now. What I can say is that evidence by the letter regarding treatment of Paisley Irons and the recommendation for parenting time for Mr. Roberts, who is her long-term therapist. He's had over 33 sessions with her. He has a history with her. They have trust between the two of them. It's clear that Paisley is willing and open to working through her issues with her mother. She's upset that her mother won't take any accountability of her actions, which is further demonstrated by the motion that points the fingers at Mr. Mead Irons versus taking any accountability whatsoever. The child feels that it's necessary to take things slowly and allow her mother time to prove that she's being honest with her. since she refuses to take any accountability for her actions, the child senses that deception. A vast majority of the allegations have already been dealt with by this court. What defendant's motion really comes down to is whether the court should adopt Ms. Katz's recommendations or Mr. Roberts' recommendations. Plaintiff is not opposed to appointing a guardian ad litem to write a report and assist the court, and then schedule this matter for an evidentiary hearing. Seems like it's putting the cart before the horse to change parenting time, adopt a recommendation when defendant's also asking for a guardian ad litem to assist the court in making a determination. So that seems like it's kind of jumping the gun there. Additionally, Ms. Katz's recommendation is essentially a modification of custody. It works up to a week on, week off schedule fairly quickly. I have nothing further, Your Honor. We just ask that.
Okay, thank you. Well, the court will inform the parties so they know that the current orders of the court will remain in full force and effect, and the court will enforce those orders. What the court is going to do in the interim is the court is going to implement Ms. Katz's recommendation up to the point of I'm not going to implement the alternating weeks at this time. The other recommendations as to, again, the phase in and the period, the time, the weekend parenting time, the court will implement that, but not the alternating weeks. The court will have that order that Dr. Haugen would conduct a psychological assessment. I think that's appropriate. Court, I know there's opposition in the answer to that, but the court has had Dr. Haugen testify repeatedly and given multiple assessments in these particular cases. And I have no doubt as to his objectivity in this particular matter. Court will likewise, as there is no opposition to the appointment of a guardian ad litem, the court will order the appointment of a guardian ad litem. The court will order that the parties would each pay 1/2 the cost of the guardian ad litem. I will give the attorneys an opportunity to try to come to an agreement as to who that guardian ad litem should be. If they're not able to come to an agreement, you can bring it back to the court, and then the court will appoint a GAL at that particular time. So with that, Ms. Reed, the court will ask that you would prepare that order. It's your subject to your motion, and you can submit under 7-day notice of entry. Okay.
No, thank you.
Okay.
Thank you, Your Honor.
Thank you. So Ms. Kaptur on behalf of the plaintiff, Mr. Todd on behalf of the defendant. This matter is before the court on the defendant's motion to change parenting time and support. Mr. Todd.
Thank you, Your Honor. Your Honor, I will largely rely upon my motion. In essence, plaintiff has sole legal and sole physical custody. There is no enumerated parenting time, simply as the parties would agree. As a result of that, we believe that we don't necessarily need to meet any threshold. The opposing party's answer is quite interesting. We aren't trying to modify the established custodial environment. She has sole legal and sole physical custody, and we understand that the established custodial environment is with Ms. Eaton. We aren't trying to modify that. We are requesting that the defendant be granted every other weekend, midweek visit, half the summertime, alternating holidays. There has been a pretty substantial period of separation. However, we would argue that that's not necessarily Mr. Metz's fault. It is accurate that there were some parenting time provided in 2019. However, though all those parenting time places were stipulated by the plaintiff. She put various stipulations on the defendant and made it unpractical for him to actually be able to exercise that parenting time. Obviously, he's here willing and motivated to see his children. And we do believe that the child support needs to be revisited through income exchange. We probably should be able to get that resolved. However, short and sweet of it, I don't quite understand the opposing counsel's argument that this would somehow modify the established custodial environment. Again, we're simply requesting every other weekend, and that would not modify the established custodial environment at all.
Okay. Ms. Kaptur, what's your response?
Your Honor, my answer is very comprehensive. First and foremost, Mr. Metz is a complete stranger to these two children. He's never even met his youngest child, even though given ample opportunity to do so, he's just ultimately failed to. He's provided absolutely no support, no clothing, no food, absolutely no care for these children whatsoever. The only reason that Mr. Metz is even coming before the court today is because Mr. Metz was facing felony charges, which he indeed pled to a felony due to his over $37,000 arrearage in child support. Because it is clear to everyone that Mr. Metz has not wanted to be a father in any way, shape, or form. Mr. Metz is now seeking to have parenting time now simply to arrange the child support so that he doesn't have to continue paying. He has to pay right now because he's on probation for that felony. And if he doesn't pay, he could end up in jail. Your Honor, the ask that Mr. Metz is asking for is so absurd and so detrimental to these children. He is a stranger to them. To have overnights with them would be extremely emotionally and physically traumatic to two children who have no idea who he is. Again, Mr. Metz knew full well, was noticed properly, that his daughter had her name changed to Peyton. He was noticed properly, failed to attend, failed to participate in any way in the last 7 months. 7 months ago, also, child support was already changed, brought down for Mr. Metz in conjunction with his felony proceedings. Ultimately, Your Honor, this would constitute a change in circumstances or would constitute a change of the custodial environment. The law is very clear. A change in the established custodial environment occurs if parenting time adjustments change whom the child naturally looks to for guidance, discipline, the necessities of life, and parental comfort. If the children are going to Mr. Metz on a standard parenting time schedule, they will ultimately change the way they look at him. However, this simply is absolutely against the best interest of the children. He has no relationship with them. They do not know him. And it would be against the conscience of the court to even award him any kind of parenting time. If this court decides that we need to have an evidentiary hearing, then I will stipulate that, yes, we can proceed to an evidentiary hearing. However, it is simply not in the best interest. There should be a higher standard of proof when looking at this change. And the child support has already been modified within the year, so there's no reason to modify it again.
Okay.
Thank you, Your Honor.
Thank you. Well, what the court does is in this particular matter, I've reviewed the pleadings, obviously, and court believes that there is a sufficient basis for an evidentiary hearing to review the issue, as there's a lot of issues on both sides as it relates to implementation of some schedule further into a phase-in period of time as well. So the court is going to refer the matter to the referee on the issues of parenting time and support. And as a result, we will have an evidentiary hearing in this particular matter. Court will conclude this matter at 9:38 a.m. You're free to go. Have a good day, and we will do the referral order, Mr. Sharp, on behalf of the plaintiff, Ms. Thomas on behalf of defendant. This matter is before the court on the defendant's motion for custody, support, parenting time, exclusive use. Again, I don't need a reiteration of the motion in this matter. Ms. Thomas, anything else to add?
Your Honor, I don't have, just for clarification, I do not have a response from Ms. Sharp. Does the court? I didn't see one logged in.
No, I don't.
Your Honor, I didn't because I didn't know that. I mean, I normally would show up to every hearing and do a response and everything. I didn't know this hearing was taking place. My client's not here because of it. And I'm not saying that Ms. Thomas didn't provide me something. I'm saying that I don't have anything to be able to refer to be able to actually address, Your Honor.
Okay.
Okay. Your Honor, the only thing that I would think that the court would need to know, in addition to what is in the pleadings, are that subsequent to us filing, Mr. Force had initially said that he was and threatened to come back to the house and actually had stayed the night there with his girlfriend there. It was very difficult for the kids. Since then, he's apparently not been back. So he's not living there at this point either, but that was his threat, but we want to make sure that that can't go back and forth. Other than that, we're simply asking that we believe that based upon the motion that it would be appropriate to have Mrs. Force have exclusive use of the marital home. She's not in a situation based upon her recent surgery that she could physically move at this point anyway. He clearly has another place to live. And so we'd ask for that, and that his shift changes. He's a police officer, so his shift changes. He has every other weekend off, and then he has a couple of days during the week. So we would ask that like the second day he has off during the week, he'd have overnight parenting time that day. And then child support, of course, based upon both parties' income, which was attached to the judgment, and it included the money he receives from the VA, which is appropriate for child support purposes. So joint legal, the parenting time plan as I just set forth, the exclusive use of the marital home to mom, and then child support pursuant to the formula.
Okay. Well, what the court's going to do in this particular matter, court does note the parties did separate on December 5th of 2022. What the court's going to do is the court is going to grant the parties the joint legal custody with physical custody to the defendant. In this matter, the court is going to order standard parenting time. However, I would note that can be adjusted based upon the plaintiff's work schedule if the parties can agree upon that. If not, bring it back and we'll adjust it. But again, it would be a standard parenting time schedule. Support would be pursuant to the guidelines. With this matter, the defendant's income of $1,550 per hour, plaintiff's income of $1,245.59 per week, as well as his monthly VA benefit of $2,247.15 per month. Court would grant to the defendant exclusive use of the property. The court would order that the plaintiff would provide health care benefits to the children consistent with the standard child support formula in this particular matter, and ask Ms. Thomas that you would prepare that order and submit it under 7 days.
Will do. Thank you, Your Honor.
Okay.
Your Honor, may I make one objection? The fact that I did not receive it, to my knowledge. I'm not saying that it didn't, but I can't adequately represent my client without receiving it. And I just want to put that on the record and have the ability to file a motion for reconsideration.
Well, you can, Ms. Thomas will provide you can send her out a copy of the motion, Ms. Thomas.
I will, of course.
In this matter, just so she has it, but okay, the court will end this matter at the appearance of Ms. Capture on behalf of the plaintiff, Ms. Ranowski on behalf of the defendant. This matter is before the court on the plaintiff's motion to show cause. Ms. Ranowski, let me ask you this: has the bridge card been provided to the plaintiff in this matter?
Yes, it has, approximately two and a half weeks ago.
Okay, and it's likewise just basically stated that court had wanted to maintain the status quo, but your client has removed the plaintiff from the Verizon account, so he can't make payment or has access to it. Is he still on the account as a co-manager and have access to the account?
Yes, he is. He made himself an account manager again.
Okay, ma'am. You have to go. We're not taking any testimony. It has to be through your attorneys. Okay.
Okay.
Okay, Ms. Capture, you can go ahead, having heard the clarification of those 2 points.
Thank you, Your Honor. As Ms. Ranowski just stated, we did receive the bridge card, but we did not receive that until March 13th. That was approximately a month after we had requested it in court, and about 3 weeks after it was due. Obviously, Mr. McMillan has been suffering from some financial hardship. He's now taking on the brunt of the utilities at the home, paying half of the bills associated with the house, and he is taking on the full responsibility of their minor daughter. Miss McMillan has had 0 parenting time. There's a lot of financial burden that Mr. McMillan is facing, and having to go through the process of filing a motion in order to get a bridge card that was very clearly ordered by this court has been very problematic. And so we're still seeking those attorney's fees and costs, Your Honor. Furthermore, Mr. McMillan has also tried to access the internet service for the house, but cannot access that because Ms. McMillan has to approve that change. And I believe there's an arrearage on the account, but there's no way to tell what that arrearage is because Mr. McMillan doesn't have access to it. So if we could also get that addressed, Your Honor.
Okay. Ms. Ranowski.
Thank you, Your Honor. As we have stated, the bridge card has been received by plaintiff's counsel. The reason for the delay is that Ms. McMillan does rely on that bridge card for her source of groceries, as well as for her minor child who is not a party to this case. It has since been turned over. Additionally, in regards to the Verizon phone account, Mr. McMillan's privileges have been restored as a manager, so he should be able to access that account now. I know that it was stated that the defendant had failed to pay the phone bill. However, she has told me that it was just the opposite. Mr. McMillan had failed to pay his portion of the phone bill. In terms of financial struggles, Tia is more than willing to have parenting time with Joey, their minor child. However, when she asked for parenting time, it has been denied by Mr. McMillan. So we would like to just state that the remedies have been already taken care of in this matter. He's already back on the account as a joint manager, and the bridge card has been turned over. So I would ask that no attorney's fees be awarded in this case.
Okay. Ms. Capture, what are the amount of attorney fees that you're requesting? I don't have that.
We requested $850, Your Honor.
Okay. Well, the court will note, obviously, there has been now compliance with the turnover of the bridge card. The court had ordered that at the hearing on February 13, 2023, that it apparently was not turned over for an additional month after that time. And it ordered as well that the status quo will remain. Apparently, he was removed from the Verizon account and was only, I guess, recently put back on the account. I don't know how that correlates to the last hearing, but it does appear that, again, the failure to comply with the court's ruling has necessitated those fees. The court will, in fact, award the plaintiff the attorney fees of $850, which will be payable within 60 days of today's date. And Ms. Capture, you can prepare that order in that regard. And the court will conclude this matter at 10 o'clock a.m. time. The court will note that Judge Yost Johnson did order or enter an order for supervised pairing time previously in this particular matter. Ms. Cervantes, is there anything else that you'd like to say?
Yes. Your Honor, in addition to my written ex parte request, I simply wanted to make a statement. Jose has proven in his words sent through text and email and actions that he is not fit to care for our children unsupervised. Jose is not following our court order by not only consuming alcohol during parenting time, but also admitting that he planned to do it. He also has failed to communicate to me his plans to take the children out of town during his parenting time. I've forgiven past incidents, but enough is enough. For example, 2022 in April, Jose was intoxicated when meeting me to exchange the children. I trusted him when he told me that it wouldn't happen again. Then I made sure to include it in our divorce judgment that he could not drink during parenting time. In July 2022 at Michigan Adventure, Jose was intoxicated and unable to be responsible for the children while in his care, as outlined in the ex parte order. Jose has been charged with 2 DUIs. Jose does not have a driver's license or legal registration on his car, yet he still continues to drive our children, not only to and from pickups for visitation, but out of town. Jose has no regard for the children's well-being when he's under the influence of alcohol. Jose has driven intoxicated with the children several times in the past. I believe that our children need their father in their lives as much as they need their mother. I have always encouraged parenting time during Jose's times of being sober, but he has proven that he cannot remain sober or act in the best interest of our children right now without being supervised. Without proper supervision, I fear my children will end up severely hurt because of his drinking. He had intended to drive with the kids in July. The trip outlined in the ex parte order took place July 10th and 11th when our son Connor was seriously hurt and received no medical attention. Our other son came home with bruises on his face and his back. Jose's drunken manner towards them the whole trip was inappropriate and unchecked due to the absence of any other adult in the care of our children during that trip. Reese, who was 13 at the time and is not related to our children by blood or marriage, is often left responsible in the care of our twins during Jose's parenting time while he's intoxicated. After that incident in July, our son didn't receive medical treatment, but Jose ended up in the hospital. He called me from the hospital so that he could receive medical treatment due to his intoxication. After that incident, Jose did not try to contact me for a few months. Jose has been able to communicate with me over email this entire time, but has chosen not to do so until recently. The children were traumatized by his behavior. They suffer due to his inconsistency and his inability to be safe around the children while intoxicated. For those reasons, I'm asking for parenting time to be modified to supervised visitations at his parents' house by his father and stepmother. His father and stepmother agreed to supervise and have already reached out to me to do so, and we have a scheduled visit for April 1st.
Okay, anything else, ma'am?
If you see so fit, Your Honor, I would like to request the motion to show cause for contempt regarding custody and parenting time on April 25th. Please be entered to allow an evidentiary hearing. In addition to the motion, Jose is claiming me wrongfully denying his parenting time. I submitted a subpoena to Michigan Adventure referring to Jose and our children to submit as further evidence to prove Jose is being irresponsible and reckless regarding our children as the reason parenting time changes. And I'm waiting in response to hear back from Michigan Adventure on the incident report. I don't want to have to ask Reese, the other child who attended the trip, to have to take the stand as a witness. However, he's the only other witness to the trip to Michigan Adventure.
Okay, thank you. Mr. Cervantes, what's your response?
Your Honor, my response is that Nicole is telling the truth mostly. It was quite a bit. I only have a copy of the ex parte. What she just said, there was a lot extra what she just said on from what I'm really prepared to respond fully on all of those allegations. But I would like to submit one thing about my sobriety right now. I have 3 papers of signatures of the AA meetings that I've attended since the incident in July. I have 150 signatures since July. I'm an active member of AA. I just left a meeting today, before this meeting. My sobriety is doing really well right now. I just moved into a new home with my 2 adult sons. Dylan is 18 and Jose Jr. is 20. I have lived with Dylan since the incident and before the incident. He's very mature and we have a very good relationship. I would like to be able to have him testify on my behalf that will state that since the incident, I've done very well, the best I've ever done in my life since my troubled childhood, since my ruined marriage because of alcoholism. I have other things that I could add. I'm very fit to take care of children, to love them, to care for them, to do everything for a child right now. 2 children, 2 8-year-old twins. Right now, besides having a driver's license, I'm very fit to be a parent. I've always been a very good parent. Besides the times that I am under the influence, I've always done a lot for my family. sober or not sober, intoxicated. I have done a lot, but unfortunately, I did make mistakes while intoxicated. There's some proof that she does have, like she stated in a text message from my cousin, I had planned to relapse. Well, my plan for that weekend was not to go to Michigan Adventure. There's a lot of circumstances about that trip, about what happened during that trip, what, when, and where. I would like an opportunity to explain it all fully. I wasn't prepared right now to do that because I didn't know that I was going to be required to do so today.
Okay.
I can retain a lawyer. I would like to clear this all up. I am very happy for the opportunity to have visitation with my son, supervised or not. I'm very happy to be moving forward in a positive direction. My family is very supportive. I'm waiting on multiple members of my family to write community support letters for me so I can get my license back very, very soon, hopefully. I haven't had a driver's license in 15 years. That does deter me of being a better parent. I had 2 DUIs before the age of 25. I'm 40 years old now. So, you know, she was making statements about that. I wanted to make sure that a little bit was clear because the duration of my DUIs were very long ago. That in particular doesn't have very much to do with my sobriety right now. Those 2 charges that I was convicted of.
Okay, let's wrap it up, sir.
Okay, yes, about the medical condition of my son's injury. Okay, my son slipped and fell at Michigan Adventure. He was treated on site by multiple paramedics, I believe. They were workers of Michigan Adventure. They made sure he didn't have spinal injuries. My son didn't feel good. He had a headache. There's no evidence of a major injury that he had. I consoled my son. I held him. I made sure he was okay. There's no proof of how intoxicated I was when that happened. There's no proof of the lack of my judgment of getting him headache medicine and waiting to make sure he was okay. Michigan Adventure can make any statements they want.
Well, sir, you acknowledge, don't you, that the judgment provides you can't consume alcohol when the children are in your presence?
Michigan Adventure doesn't have proof that I was doing alcohol that day.
It's all right. I'm asking you. I'm not asking Michigan Adventure.
I understand.
You understand that's a prohibition, don't you?
I do now. When I signed the divorce agreement, I did not know that. Unfortunately, I just signed the paper. I didn't read it.
Okay.
I was wrong for that, but I understand it now.
Okay. Well, in this particular matter, what the court's going to do is the court is going to continue the ex parte order for supervised parenting time entered by Judge Yost Johnson. That means that the parenting time, any parenting time, would be supervised. Apparently, your parents, Mr. Cervantes, are agreeable that the supervision can occur in their home. So the court will order that that supervised parenting time occur in the paternal grandparents' home. Court would reiterate that you'd not consume any alcohol during or before the parenting time. And the court would order as well that you would not drive with the children in the vehicle until you have a valid driver's license. And Ms. Cervantes, I'll ask that you would prepare an order which would reflect that particular ruling. You can submit it. If you submit it within 7 days, you can submit it under a 7-day notice of entry. If you don't get it submitted within 7 days, you're going to have to notice it up for entry and have a separate hearing, okay?
Thank you.
Okay, thank you. That will be the order of the court, and you're free to go. Magnuson, on behalf of the front of the court, this matter is before the court on the defendant's motion to set aside referee order. Mr. Moore, you state in your objection or your motion that first you say, I need to know if baby is mine, and you say support based upon incorrect information. Is there anything else, sir?
That's pretty much. I haven't even had a DNA test to establish that I'm the parent of the child, and they told me when when I was there, you told me, I looked at the paperwork, they based the amount that they had it on with $700 of me having one kid on child support, as well as making $5,500 a month when I got terminated from my job on February the 15th. So I don't even have a job. I mean, I did just recently get hooked up with On Staff. So.
Okay. We lost him, I guess.
Yeah.
I'm sorry, the phone got disconnected, but we got somehow disconnected.
Okay. Anything else, sir?
No, sir.
Okay. Mr. Magnuson, maybe you can enlighten the court what's happening.
Your Honor, we did set support, or based on what information we had at the time, it would appear that after the fact, Mr. Moore had loss of his job, but we used the information that we had and we included that in the complaint. He did not file any type of answer, and as a result, a default did enter. So from our perspective, those amounts are taken as admitted. Obviously, I have no problem going forward with support review or any steps that Mr. Moore wants to take to have that amount looked at. As to the paternity, again, that was offered to him during the pendency of the case. But that being said, in the spirit of wanting to get things right and make sure we have the right parent, we're willing to agree to do the genetic testing. This is a paternity case brought to us from another state to establish that. So we would be able to do that. I would just need something in whatever order the court prepares coming out of this, indicating that it is ordering genetic testing. So I'm not opposed to that.
Okay. Well, what the court will do in this matter, obviously, as Mr. Magnuson states, we want to get it right rather than to just get it over. The court will order genetic testing with the defendant and the minor child. Court further will, again, I guess, pending the result of that genetic testing, the court would order a support review in this particular matter, but let's wait until we get the genetic testing completed and the results, as it may be a moot point. I don't know.
Okay, I just recently got like 6 different income withholdings. So at this point, still, while we figure it out, they still can take my money without even establishing if I'm the parent.
Well, they will take it until we what we're doing is we're doing a review. So you'll have to get you have to get your current income information in, et cetera. And the court again is going to give you an opportunity to address the paternity issue, but I'm not going to suspend the support amount until such time as we have a determination. So what you need to do is contact Mr. Magnuson at the front of the court, arrange to have that paternity testing done as quick as you can, because once we get that result, we could address the support at that particular time.
So I'm kind of trying to understand the process, Jan. I'm just making sure. So until you find out, I'm ordered to pay $700 a month when I don't have a job. So I'm steady going in the rearage on something that hasn't been established.
Well, it's been established at this point, sir. There is an order of affiliation in place. And as Mr. Magnuson said, you had the opportunity to contest paternity in that proceeding. It didn't happen. We're giving you that opportunity now. And depending upon the results, that will depend upon what happens with the support obligation as well. But I want to find out and determine paternity first, and then we will address the support issue.
Okay. I mean, what's my next step then? Because I mean,
your next step is to call Mr. Magnuson, set up to have a paternity test done.
Okay.
And he's at the front of the court office. You ask for Mr. Magnuson. He will set it up and get it done. We get it done pretty quick. So if you can get in this week, you can get that testing done. We can get it completed, and then we can proceed with the matter on your support.
Okay.
Okay. Thank you.
Thank you,
Court will conclude this matter, and you guys, you have a good day. Note that this matter is before the court on the plaintiff's motion for 401k and tax return. That's what you're asking for. Apparently, Ms. Daniel, what is the basis and your authority to get that? I don't understand. You're just telling me what you want. You haven't given me a basis as to why you should be able to receive that.
I need to pay off my debt in order to get a house for me and my kids. And I need to get a car so that way I have transportation for me and my children.
Okay. You still have to establish a basis for it. And you have in your pending case, you have discovery that's still open through May 1st of 2023. And the case will progress as the case normally progresses. So for instance, what happens is we don't allow people in that to piecemeal a divorce case out like, okay, I want to get a hold of this, for instance, or I want to attach this bank account. We basically wait until we have a resolution of the case, and then we divide up the particular assets. So not to say you can't on a temporary basis that you couldn't file for something, but I can't give you any legal advice, but it's up to you to establish what you want and the basis for receipt of what you want as well. So anything else that you can tell me other than you want to get a hold of that?
I have to provide for my kids and stuff. And that's the only way, what I got right now. He's not paying for the baby since the day that we left. He won't buy the baby diapers. He's not buying him anything.
Well, ma'am, what you can do is you can always file to get child support. And
that's what I want to do, sir. I want to get child support for all 4 of my kids.
Okay, what you're going to have to do is you're going to have to file a motion seeking child support. You can basically, in the motion, set forth the factual basis as to why you're entitled to child support. Obviously, they're his kids, he's required to pay child support, but you'd have to state to the court, for instance, that he hasn't paid you anything. I don't know, because I'll tell you what happens in these cases. He could come in and he could file an answer and say, no, I've been paying her all along. And, here's my receipts or what my canceled checks or whatever. I don't know until the matter is before me. That is not before me today. So you're going to have to file a motion. He can then respond and then we will address it. And so you can file that for any Monday with 9 days notice, any Monday at 10:30, and then we can address it at that particular time. Okay.
Okay. Now, in the meantime, how do I get this 401k? Because I heard I'm entitled to it and his tax money.
Well, you're entitled to it as a result. Okay.
Support my needs.
You're entitled to it as a result of the divorce action. Okay.
Okay. So it would come later, basically. Is that what you're saying?
Yes, that would come later. Correct.
Okay.
So at this point, you can file for support, however, and you can file that at any time. So you can file that and you can have a hearing on that again upon 9 days notice. And notice.
Okay, so it's like spousal support. Is that what you're talking about? That I can file for that?
No, child support. If you want to file for spousal support, you have a right to file for that too. But you have to establish your factual and your legal basis for that. Okay?
For sure. I'm going to go file for child support sometime next week.
You do that and you provide that paperwork to the defendant, and then he has a right to respond, and then we'll consider that at the hearing.
Okay.
Okay. Thank you. Court will end this particular matter at 11:02 a.m. You're free to go. Have a good day.
Thank you.